all of you who joined. This is great to see such a big crowd. So this is the second time uh, at AI for Libraries that I'm speaking. Anu invited me, I guess it was two years ago. Uh, and it's really been pretty interesting to see what has happened in copyright over the last couple of years. The dynamic of what's happening in both the legislature and the courts has changed quite a bit. Um, and I think that, 2 years ago, a lot of us had a number of questions that we really were just sort of guessing at what the answers were. And today, we're kind of still guessing, honestly, but we have a little bit more to go on. So, what I want to do today is really focus in on one particular piece of the copyright and AI questions with respect to libraries, and that is about training data. There are a couple other sessions. There's one that I'm really excited right after me that's going to deal with AI bots and scraping library data. Um, but there's some really important legal questions and policy questions raised by the use of library materials for training data. So I want to acknowledge there are like a bunch of other copyright questions that I think are important, dealing with, for example, the protectability of AI outputs, which we're increasingly seeing being incorporated into academic publications and other materials. Um, there are also lots of questions about liability for use of these systems. For example, researchers using these systems to generate outputs that might be similar to pre-existing works, or maybe are generating outputs that have defamatory content or all sorts of problems. So I just want to acknowledge that those exist and then tell you I'm not going to talk about them at all. I'm really going to focus in on the trading data question because I think it has become the most important issue, both for the copyright and AI litigation and policy space more generally, but also for how libraries fit into the picture of AI technology development. Um, so before I get into that, I thought I should tell you something about Authors Alliance because some of you may not know what this organization is, and I think it's always nice to know who it is that is speaking to you. So Authors Alliance, as Anu said, is a nonprofit that exists to advance the interest of authors who want to serve the public good by sharing their creations broadly. One of the things that we really focus on is that to do that, to be that kind of author, you need to not only be able to share your work, but you need to be able to do the research that underlies it in order to produce your work. And so we often find ourselves advocating in the copyright area for policies that allow authors to gain access to research materials so that they can do their work and write and share their ideas with the world. Um, in particular, we've worked quite a bit with text data mining researchers, AI researchers, folks in the machine learning space, because they are facing many copyright challenges right now. And I'll talk through those in just a moment. So one of the things that we do is we try to help educate people on basic kind of important issues that deal with legal dimensions of research and writing. So on the left-hand side of the screen here are some examples of guidebooks that we publish. You'll find these all free on our website. And the other thing that we do is we involve ourselves in litigation with some frequency, particularly on issues affecting fair use and copyright. So this is an example of a brief that we filed. This was actually the very first brief that we filed in the Authors Guild versus Google case, which actually, in a lot of ways, raised many of the same copyright issues that we're seeing now. Of course, this suit was 13 years ago at this point. This particular brief was filed.
Dave,
So,
Dave, to
Dave,
interrupt.
we're not seeing your slides.
oh, I'm so sorry. Uh, Let me get these up. Um, Now you can see
Yes,
the guides
perfect.
on the left, the brief on the right. Nothing else that I showed so far was particularly important, but that's the two visuals. Um, so we do a number of projects too. So I'll just throw these up because they're cool projects and you might be interested. And one of which I'm going to talk about at the end of this talk, the Public Interest Corpus, which is focused on developing large-scale, high-quality AI training data from the world's memory organizations to serve the public interest. Um, So the other things that we work on are open access policy, copyright policy in the AI realm, which is a project at the top. Um, and I just like this picture on the bottom. It's a podcast that we do, so you should check out our podcast. It's usually pretty fun. We co-host it with the Internet Archive, and we mostly do book talks with people who write interesting books on kind of information policy and creativity. All right. So I'll race through this. We also partner with libraries. So I wanted to throw this up, not to give you a sales pitch, but to highlight that what Authors Alliance does is really enmeshed with the work that libraries do. Libraries serve, particularly academic libraries, serve the authors on their campus in important ways, helping them navigate legal copyright issues. And so we're really proud to partner with these different institutions. If you have any interest in working closely with us, I'd be happy to hear from you. All right, so now the meat of what I want to talk to you about. Uh, Copyright and AI has become kind of a thing. So if you look at the copyright lawsuits that have been filed since around November of 2022, you will find a massive number of suits that have focused on artificial intelligence. This is a chart that's produced by a website that I read almost every day called ChatGPT is Eating the World. It's run by a law professor at Santa Clara that tracks basically every copyright lawsuit in the United States that's been filed in the last several years. There are over 50 lawsuits now pending in the courts. A huge number of these are really big lawsuits, like class action level lawsuits. Um, and they're all over the country. They've been kind of concentrated in a couple of places. So the Northern District of California is where we have a lot of these. And then the Southern District of New York. So, for those of you who don't know those districts, uh, San Francisco and Manhattan. So that's not a huge surprise. And that's kind of traditionally where we see a lot of the copyright lawsuits pending. But there are some other important ones as well. For example, in the Third Circuit, there's a really important case that actually we Authors Alliance just filed a brief in on Monday about AI training to produce a legal research tool using materials that Thomson Reuters, Westlaw, basically claims to own. So that's an interesting case. It's not exactly generative AI, but a lot of the principles there translate directly. And so that's a pretty important one to watch. So I wanted to throw this picture up here, partly just to impress on you that this is a very complicated and dynamic space. These lawsuits are being filed and dismissed and filed and dismissed and kind of winnowed down into some of the claims that are really, really important to keep track of. And I think for most of us, if you've worked with copyright law at all, you know that one of the really big questions that's going to show up here and is showing up in these cases is whether the use of copyrighted materials for AI training is a fair use or not. Um, and that's a really big deal because of the way that most of these companies, and not just these companies, but AI researchers, anybody who's engaged kind of in this space, how they've gone around and collected data. For the most part, it has not involved a whole lot of licensing. It has not involved going to publishers and saying, will you please let me use your materials and here I will sign this license. Now that has happened, but the bulk of the content that people are using for AI training is coming from all sorts of sources. And we're going to get into a couple of those sources in just a moment because I'm going to focus in on one of these lawsuits. Uh, but AI training has come from just all corners of the web, and using sources like Common Crawl, which crawls the web very broadly. It uses all sorts of different formats, music, email transcripts, captions from YouTube videos, all sorts of materials are being fed in as training data for these models. And so there are lots of different types of suits. Lots of these suits are focused on text, but actually lots of them are image suits. There's a growing number of music lawsuits pending. You can see a few of them up here. One of them just settled 11 Labs. So those are growing in importance as well. So this is kind of a messy space. Um, I want to talk to you about just one case because I think it's a pretty interesting case study. So many of you have probably heard of the lawsuit Bartz versus Anthropic. Um, and I want to just take you kind of through a journey of what's happened in that case to use it to explain why I think it's pretty important that libraries be actively engaged in a discussion about how their materials, both books, serials, all sorts of things, but particularly books, can be used in a productive way for AI training and not in counterproductive ways. So Claude, Claude is the chat interface that you can interact with that a company named Anthropic produces. It is one of Anthropic is one of the largest AI companies that produces foundation models. They have a number of them. I think they just rolled out a new one the other day. And these large language models are trained on very large amounts of text. Um, and among the things that Anthropic has trained Claude on are books, and actually lots of books. So there's this lawsuit, the Bartz versus Anthropic lawsuit that was filed against Anthropic. And at the beginning of the suit, we really didn't know a whole lot about where Anthropic got these materials from. And this is sort of a sidebar, but one of the kind of unfortunate effects of all of this litigation, these 50 plus lawsuits, is we've really lost a lot of transparency about what these companies are training on. If you rewind the clock and go back about 5 or 6 years and you look at AI or machine learning papers posted on Archive, you will find all sorts of information disclosed about the training data that people at Google, people at Meta, people at OpenAI are using to build and refine their models. As soon as the lawsuits started flowing, everybody stopped disclosing the materials that they were using for pretty obvious reasons, right? You don't want to give plaintiffs ammunition to go file lawsuits against you. So at the beginning of the suit, we really didn't know where they were getting books from. But through the course of litigation, we've discovered actually a few things. One is Anthropic, at least early on, sourced a number of its books from some of the sources listed on the left-hand side here. So the top is actually an article by Alec Reisner published in The Atlantic that digs into a data set called Books 3. Books 3 it contains about 183,000 books, mostly like modern trade books. It's about a half or maybe a little bit more fiction and nonfiction, popular books. Um, and that data set has actually been featured in a large number of these lawsuits. Um, and obviously those materials they were not obtained with any permission. Um, so that's one source that Anthropic obtained materials from. The other two are probably also familiar to at least some of you. They obtained about 5 million volumes from a website called LibGen, uh, Library Genesis, which actually has its origins as a sort of post-Soviet Russian shadow library, a way for people to share um, materials online when there's a lot of censorship and other barriers to gaining access. That had kind of morphed over the years into LibGen, which is a very, very large data set of books and other materials, but a very large data set of books that were obtained without permission. The judge in this case describes it as pretty straightforward pirate library. And then in addition to that, Anthropic sourced some books from a very like clearly named source, the Pirate Library Mirror. So I think that kind of explains what is in there. So between LibGen and Pirate Library Mirror, PyLMI, there were about 7 million books that Anthropic obtained. But then one of the other interesting things that Anthropic did is a couple of years ago, they actually stopped downloading or obtaining and using materials from those kinds of sites, and they shifted to buying books. And I don't think we have the exact number of books that they purchased. But what they basically did was they went out and they bought what we know are now millions. We don't know exactly how many millions of books that they scanned. Um, as far as I can tell from the opinion in this case, destructively scanned, meaning ripped the bindings off, fed them through a sheet scanner, I think, is the most efficient way to do that, and obtain their training data that way. So that's a kind of interesting nuance, but actually isn't that far off from what we've seen other technology companies do to obtain books. It's a little more dramatic in the way that they're doing destructive scanning, but you might recall that Google has been digitizing books from libraries for almost, actually over 2 decades now. Um, and they were sued and they actually won a pretty significant lawsuit back in 2015 when the Authors Guild sued that suit that I mentioned earlier, and won on fair use grounds. So Anthropic decided they would kind of take the same approach. And in fact, if you read the decision, you find out that Anthropic also just went out and hired some former Google Books employees to work on the project for them. So that's how they went about getting books. Um, in 2024, late 2024, a number of authors, three authors in particular, Andrea Bartz, Charles Graeber, and Kirk Wallace Johnson, sued Anthropic for copyright infringement. Um, Now, a couple of things to note here. One is they sued for copyright infringement on a pretty narrow set of claims. So if you read some of these lawsuits, they are about not just the use of copyrighted works for training, but also for the outputs that come out the other end of these systems. So, you may have seen, for example, the New York Times lawsuit against OpenAI, where they very prominently put up this image in the complaint where they showed how the New York Times article was on the left, and then they did a red line of an output from ChatGPT, and it showed that there was, remarkable similarity between the outputs. So there are copyright cases dealing with that output similarity problem, but this case was actually pretty narrow, which made it easier to resolve in a faster way. It was really just dealing with the issue of can you use copyrighted materials to train a model? Um, and so that's one important feature. The other important feature that I want to point out is it was filed as a class action complaint. So what that means is basically the three authors who filed this said, we are filing this on behalf of ourselves and all of the other people in the world, or all the other people in the class as we define it, who are similarly situated with us and who are harmed in the same way that we are. So as you might imagine, you're not allowed to just show up in court and sue on behalf of other people without the court investigating that at least a little bit. And that was something that happened in this case. We'll go through what happened there through a process called class certification. Um, so this was the original class that was proposed. It was supposed to be really a class that focused on authors, um, all natural persons, natural people, that is not companies, but natural people, their estates or literary trusts that are legal or beneficial owners of a copyrighted work that was registered with the Copyright Office and that was used by Anthropic in its training, research, and development of its tools. Um, so that was like a pretty broad class definition. Um, but it wasn't as broad though to include all rights holders. It really did focus in on authors or individuals who were the copyright owners. Um, so, excuse me. So this is a pretty big deal lawsuit um, to file a suit basically on behalf of all copyright owners or individual copyright owners, anyways, primarily authors of those 9 million-ish books that were used by Anthropic. We don't, like I say, know the exact number. Um, and this wound through the courts with relative speed. Some of the other lawsuits that have been pending were filed over a year before this, and we still don't have decisions on, for example, whether fair use applies. But in this case, we actually do. This was the first case where we got a real full-fledged fair use analysis on the use of copyrighted works for large language model training. And it was pretty enthusiastic about fair use applying to these kinds of uses. So I won't go through the entire four-factor fair use analysis. I guess for the benefit of folks who aren't familiar with that at all, you should know that fair use basically it allows for third parties to make use of copyrighted works without gaining permission. But what happens is the court looks at a number of factors, four factors in particular, to decide whether that use is or okay or not. The first is the purpose and character of the use, including looking at whether the use is transformative or not. That is, whether it does something new and adds new meaning or message or purpose, or whether it just sort of substitutes for the original. That's one of the really important questions. The courts also look at the nature of the underlying work, like is it very close to the core of what copyright is designed to protect, like highly creative novels, or is it something kind of at the fringes, like maybe Yellow Pages, or something that's like primarily factual but has a little bit of creativity in it. Um, the third factor looks at how much you took, although in a lot of cases, including in this one, the amount that you use becomes less important when it is tailored to achieving a transformative purpose, which is what we ultimately had here. And then the last factor looks at the effect on the market for the original work. So copyright in the United States is primarily an economic regulation, and so one of the things that the courts are really concerned with is, are you destroying the market that the law was designed to create for that original work? So in this case, the court looked at this and said, this looks pretty highly transformative. It said Anthropic used these works to iteratively map statistical relationships between every text fragment and sequence of text fragment so that a completed large language model could receive new text inputs and return new text outputs. This is really different from the reason why authors write books in the first place. It is not typically to allow people to extract statistical information about the relationships between text fragments within their work. So the court actually described this as quintessentially transformative. It kind of analogized it to a reader aspiring to be a writer, and how Anthropic's LLM, trained upon works, do not race ahead and replicate or supplant them, uh, but they create something different. One of the analogies that the court used was that this looked no different to it than like a reader going into a library and reading books, and gleaning ideas and information from those things. And as long as it wasn't reproduced entirely in the outputs, that seems like a reasonable kind of use. So that was the first factor, and that was particularly important on the large language model training. Uh, the second really important holding of the court was that the large language model does not cause market harm. The copies used to train specific large language models did not and will not displace demand for copies of the author's work, uh, and not in a way definitely that counts under the Copyright Act. So this is a really important one. Uh, to contrast with what we've seen in one other case. There's another book case where we have a fair use decision, um, Kadri versus Meta. And there, the court had a lot of misgivings about what was happening on the market harm factor, not because there was any evidence that the LLM, in that case, Meta's LLM, was displacing sales of specific authors' works, but because the LLM could ultimately dilute the market by enabling the creation of so many copyrighted works or so many new works that it would make it so that people wouldn't want to buy the author's originals. So that was a really interesting and kind of novel approach to market harm, actually, and has received a lot of criticism. And really, no court has adopted that kind of view before. And when you think through that sort of market dilution theory, it has some appeal because I think a lot of us are sensitive to this idea that, well, LLM might be displacing different authors' business models. Um, but it's not the kind of harm that copyright really was ever designed to protect from. And in fact, copyright actually encourages market dilution. The whole point of copyright is to incentivize people to create new things, including new things in that same kind of general genre. So that's what the court has said about market harm. So overall, the court concluded that large language model training, in Anthropic's case at least, was a fair use. But that didn't mean Anthropic got off entirely. Um, One of the real problems that Anthropic ran into was that it downloaded all of these books from pirate library websites, um, and it didn't always have a clear use for them. And so the court kind of construed this as Anthropic creating what it called a centralized library. And it had a very different take on the legality of downloading things from LibGen or Pylami and just retaining them. Um, so the court said that this is basically just like piracy. You downloaded it from a pirate website. Um, and you can't just say, "Oh, I might use this in the future to train LLMs." The use that was in front of the court was just retention, and so the court said, "No, that doesn't seem transformative at all." Um, and it further concluded that those uses, what did it say? Plainly displaced demand for authors' books copy for copy. And so essentially on this issue, the court said, um, it sure doesn't look like fair use, but I don't have enough evidence to quite get there yet. There wasn't a motion from the plaintiffs for summary judgment going the other way. And so ultimately, what happened was that the court said this has got to go to trial. Now, one of the things in the background here that's really important to know is that in copyright law, uh, copyrighted works that are registered with a copyright office contain or could lead to potentially very, very hard, high damage awards, up to $150,000 per work infringed. And so, even though Anthropic won on the core issue of is large language model training fair use, the fact that it lost or it looked like it would lose on this pirated books issue was really important because it could have meant potentially ruinous liability. So if you take the roughly 7 million volumes that are included in the Pylami and LibGen dataset, and you multiply that times $150,000 per work, you end up at pretty astronomical potential damages. And so that was a really scary thing for Anthropic, particularly after the judge decided to certify the class. That is, giving the class representatives the official ability to represent all of these other people that fall within this class. Um, and so what it very quickly led to was Anthropic settling the case. And this has been in the news all over the place, a $1.5 billion settlement. And this is a post from Authors Alliance. I think one of the things that really has been misconstrued about this settlement is that it really isn't a settlement about AI training at all. It's really a settlement about downloading books from pirated websites. And that's essentially it. Anthropic already won on the fair use issue for training. Really the only issue that was left was their downloading and retention of copies from these pirate websites. So that's essentially what the settlement is about. And I can tell you a lot more about the settlement. It has lots of twists and turns. It's complicated, like settlements are. The numbers always look bigger than they are, too, I will note. So, the lawyers get their take. The plaintiff's lawyers in this case, for example, stand to take home something like 25% of the settlement. So that would amount to, I think, $380 million or something around there. So there are lots of twists and turns, but I just wanted to mention the settlement piece because it's been so much in the news, and I think there are lots of questions about what it is and what it isn't. Um, all right, so that's the end of my lawsuit summary for you. Why did I tell you all of this? One, because it's kind of an interesting suit to understand. It's one of the very first that we have a fair use decision in, and it's also, I think, very directly applicable to libraries because it is so focused on the kinds of materials that libraries have in their collections. Um, so, so one of the things that this raises is how will these AI companies get access to books? How will researchers get access to books in the future when they are doing AI research on campuses and nonprofit research centers, et cetera, in light of the ruling that we have in this case? So I want to rewind a little bit because this is actually something that people have been thinking about for a while, including myself. So this is a paper that was published in April of 2024, following a series of workshops on what it would look like to actually build a book data commons for AI training. It involved discussions with a number of stakeholders, including some people from AI companies, including people from universities, people from libraries, um, and it kind of outlined, it sketched kind of some ideas on what this thing might look like. So this really sparked my imagination to investigate this a little bit further. That combined with a number of developments that I had seen around the importance of high quality training data. So you'll see over and over again that in this space, really it is garbage in, garbage out. And so it's really important to have high quality training data. Judge Alsup talks about this in his decision about why the books were so important. He says books are especially valuable training material. As one commenter puts it, books offer formal and lengthy text, which helps LLMs understand complex language structures, grasp long-term context, and produce coherent narratives. So this is just one of, I could put probably 24 quotes like this up here from a variety of research papers explaining LLM training and why books are so critical for this. So, um, so after that white paper came out, me and Dan Cohen, who is the university librarian at Northeastern and also a historian and also a board member for Authors Alliance, he and I kind of worked through some ideas on why books were such a problematic issue for AI model trainers, particularly big AI companies. Um, and what libraries could potentially contribute to this space. And part of our reflection was that we don't think it's great that these companies are going around to sites like LibGen and PyLMI and grabbing kind of whatever they can get their hands on to train their models. For one, it's not great to support those websites, and there's lots of shady aspects of how those sites work. But in addition, they're just not very coherent sources. So, if you look at those 7 million volumes across LibGen and PyLMI, there's some very interesting characteristics to them. We actually have a write-up on our site where we investigated them based on the metadata files. And they have kind of odd focuses that don't necessarily reflect the kinds of materials that you would really want to see in a comprehensive, cohesive collection or corpus of materials to train an LLM. For instance, the language diversity is really bizarre. Remember, the sourcing of LibGen originated in Russia. There's a bizarre kind of language split of predominantly English, but a very strong number of materials in Russian, and then like virtually nothing else in other world languages, as far as we could tell. Uh, it also has some very funky focuses on different academic disciplines. It's very computer science heavy, but leaves out a lot of the humanities. So you have some real oddities when you just go and grab kind of whatever you can get on the internet. And there's a much better way to do this. One of the other big reasons why I think those sources are not great for AI training is they leave out actually a lot of people who don't have the economic wherewithal or the litigation risk tolerance to say, I'm going to go download a pirate website and train my model on it. So I guarantee you, for those of you who are at academic institutions, If your researchers show up in front of your general counsel's office and say, I found this thing on the internet on a website called the Pirate Library Mirror. Can I use it to train my model or refine my model or do text data mining projects? Uh, they're not going to be really excited. Um, Institutional users, academic researchers are a lot more sensitive to litigation risk and other kinds of reputational risk that just drive them away from using those sources. And that's really unfortunate because one thing that that leaves us with is a situation where people in academic institutions, small nonprofits who just can't handle that kind of risk, they don't have the venture capital money to just throw at hiring lawyers to deal with lawsuits. What happens is they just don't get access at all. And that's a really bad future to live in, where the only people who can afford to do this are basically the ones who can either pay for licensing or pay for lawyers to make the problem go away. So, um, so those are some of the things that Dan and I wrote about in this piece titled "Books Are Big AI's Achilles Heel." One of the things that that piece led to was the Mellon Foundation giving us some support to investigate what would this look like if we really brought libraries together and tried to find a pathway to providing access to a corpus of library materials, particularly books, to provide some sort of counter source for both or potentially both commercial AI uses and academic uses. Um, our kind of basic ethos here is that collections should be made available under ethical and fair rules as the raw materials that will enable computationally intense analysis, the kind that's needed to inform AI models, algorithms, applications imagined by a wide range of organizations and individuals. So there's a lot that could potentially be done with such a thing. But it also raises lots of questions. What are the goals and missions of something like this? Is it really going to provide access to these commercial companies that so many of us are just a little bit nervous about? Is it going to be focused more on academic or research uses? There's lots of technical and logistical challenges. Just sharing millions of copies of books raises all sorts of security concerns. And so data access and data security are really important. Governance, I think, is also important. And we've seen some really interesting governance models emerge over the years to help make sure that digital libraries and other contexts are both sustainable and meeting their public interest goals. Um, and a number of other issues, not least of which is the last one on here. What combination of legal pathways is acceptable? Um, so one thing that I will say on that has been encouraging in both the BART suit and the others where we started to see glimpses of how fair use will apply to questions around use of copyrighted materials for language model training is the courts have been very careful to say that whatever's going on in the case in front of them, which is primarily commercial uses, there may be other uses out there that have a different analysis and maybe a stronger analysis under fair use. Although in the Bart's case, it was kind of hard to have an even stronger statement in support of fair use than what the court did. Um, Nonetheless, in all of these circumstances, it's been flagged that research uses really look like something that there should be a strong fair use case for. So these are some of the questions that we set out to resolve. Um, this this project that we stood up or that we're working on now is called the Public Interest Corpus, um, focused on developing a large-scale, high-quality AI training data from the world's memory organizations. So basically what we're doing now is we're going around and talking to lots of people at big libraries, but also smaller institutions about what do you think this thing should look like? And it's been a very interesting set of conversations. Some of those conversations have gone in the way that you might expect, where people say, what do you mean? What should this look like? Why are you doing this in the first place? This sounds horrible. We think AI is the worst thing to happen in the last, couple of decades at least. And a real kind of reverse of like we don't want anything to do with this. But for the most part, it's been a very thoughtful and engaged conversation with different stakeholders. And by that, I mean librarians, archivists, uh, publishers, authors, researchers, um, about what such a thing could look like that really serves the interests and the missions of libraries first. Um, and I think kind of embedded in that is that the mission and interest of libraries is really coterminous with the mission and interests of readers and learners. Um, and so I think that conversation has been actually pretty productive, about kind of a recognition of the reality that this is happening. AI training is happening, and AI training using books is happening. And so we can't really pretend that it's not happening. But if we want to have a better future where AI training is not just on random books found on the internet or social media posts or Reddit or 4chan or whatever kind of crap that's out there, if you want it to be more reliable, then the institutions that have focused their entire being, their entire existence on the preservation and access to reliable information should have a seat at this table. So that's the public interest corpus. Right now, we're kind of in the planning stages. We've held a number of workshops. We're going to hold another workshop a little later here in October in the Bay Area, and then kind of roll out what we think is a reasonable startup plan for this, hopefully with maybe a pilot partner to get this thing off the ground. Um, I throw this slide up here, honestly, partly just to glean a little bit off the goodwill and fame of some of the people who have been involved with the project. Because I'm really honored and proud that this advisory board came together to work with us on this project, and they've been very involved, giving us lots of guidance and ideas along the way. Uh, and I think that that's actually pretty important that we have a group of people representing a wide variety of libraries and other kind of organizations, as well as authors, um, to help us try to pull together, with especially the diversity of information that we're gathering in other places, something that could resemble a plan that reflects kind of a broad, if not consensus, a broad-based understanding of how AI and library collections can fit together going forward in a way that really serves library interests first. So I'll stop, and I think we maybe have some questions. But my main point with all of this is to give you an overview of the law and where things are at right now. And of course, cases could be appealed, law could change, lots of stuff could happen. But with the law that we have, the big question I have for you all is how can libraries lead in this space with their values? And particularly in a world where AI training is going to happen, how can we shape a future that promotes access to knowledge, supports research, and enables new uses and users? In particular, I think of all of the students that I teach who maybe don't even step foot in a library, but use these AI tools. How can we engage with them through these tools to bring collections to bear? So I think there's a lot of opportunity. And I think that at least right now, there's a pretty decent and clear legal pathway to do that. And so I think it's a really important moment for libraries to kind of step up and think creatively of how they can engage here. All right, so I am going to stop sharing my screen and see what we've got for questions. So there's a question in here about how can I protect my work from being scraped or used in AI training? This is a great one. There are a lot of things that you can do to prevent your work from being scraped. Whether they're effective or not is another question. So in the European Union, there's a legal framework that is emerging that basically says for research purposes, you can't really opt out. That's just not a thing. If you release your work into the world, people are allowed to read it, people are allowed to learn from it. Researchers are allowed to do that too. But for commercial applications, there is sort of an opt-out regime, and there are a number of standards being kind of developed or batted around in the EU around how to effectively do that. The standard is that it has to be machine readable, but beyond that, there's a lot of questions still open. So that's probably one of the most effective pathways, is to kind of do that under what is emerging as the European model. Now, you might be saying, well, that's Europe. We're in the United States. Why would that matter? But what we've seen consistently in a lot of kind of online tech regulation over the last 2 decades, really, is the so-called Brussels effect of the EU regulating in a way that other countries have been hesitant or even reluctant to do. And just for ease of operations, if nothing else, the bigger players will just kind of abide by those rules everywhere. So I wouldn't be surprised if that kind of model takes hold. A number of these companies have explicit opt-out mechanisms. OpenAI has you just search OpenAI opt-out, and you can try to opt your material out there, and that's a pathway. So there are ways to make your wishes known. All that said, if the decision in this case, in the Bart's case, holds that AI training on copyrighted works is fair use, then there's nothing, at least in copyright law, that is preventing someone from using your work for AI training, uh, regardless of whether you'd like it opt out or opted out or not. Now, that's not to say there aren't other legal mechanisms or practical mechanisms to prevent it. Um, I think we're going to hear in a moment here about some ways that, excuse me, libraries have been sort of overwhelmed with AI bots, and so maybe some potential ways to keep their material from out of AI training, or at least keep the bots from overrunning their websites. So there are a couple questions in here. I'm sorry I didn't get to these earlier, but I'll get to them now. How do most of these cases define training a model? And does it have to be more of a large-scale effort by the AI companies themselves? Um, Not necessarily. So I would encourage you to take a look at Judge Alsop's ruling, and I can put in a link here in a moment. He was very thoughtful. Actually, before the litigation even really got going, he held a tutorial session with the parties where he basically had someone come into the court in a non-adversarial way and just teach him how AI training worked, which I thought was actually a pretty good approach. But no, it's not necessarily defined by the scale of the effort, but more about the ways in which these models are built on understanding statistical relationships between fragments of text. So the idea that they're not just like photocopies or pastiche or a collage of words being put together, but that they're a real model based on relationships between words and underlying texts. And we see that in other cases in maybe less sophisticated ways. So, for example, 20 years ago, there was a lawsuit about the Turnitin.com plagiarism detection software created by iParadigms. And the court in that case said, this looks to us like fair use because this is a model that's identifying patterns in texts and producing some new different outcome from it. In that case, identifying plagiarism, even though it reproduced the entire texts in the underlying data set. Um, it is true. Nicole asked, I think I read somewhere that they never used those pirated books for training. Is that correct? So uh, one of the things that was never really clarified in the suit, that we never learned because it didn't go to trial, is what portion of those works were used for training and what portion were not. It seems that some of them were used for training because we know, based on the facts laid out in the case, that Anthropic had used those pirated materials early on in the development of its early models and then switched to its scanning operation later. And so it seems pretty clear that they did use some, at least in early versions, but we don't know what percentage exactly. And I don't think we'll ever know, given that it's not going to trial and the case has settled. Um, so another, similar to the question about protecting work, uh, Deirdre asks, how have open access repositories talked to creators about this particular model of use of their content? how can they get credit for putting their work in the public corpus? This is a really important question. Um, and I think the attribution issue has been, at least for me in talking with academic authors, one of the most important issues for them. I talk to academic authors all the time who say, I'd actually kind of like my research to be included in these things so that if people are looking and trying to understand my particular area, they'll have quality answers and not like made up stuff. But I'd like to be able to get credit back to me. So actually, one of the things Authors Alliance has been working on is hosting a kind of roundtable workshop, hopefully with some of these AI companies to talk through how they can improve some of their attribution issues. There are some pretty good models, though. Like, for instance, GitHub has its Copilot tool that allows you to use it to generate code. One of the things that GitHub has rolled out is a tool that will attribute if the output includes a string of code longer than n characters. I don't remember how long it is, but if it produces a certain length of string of code that matches something in the underlying training data, it will point you back to that training data and say, here's where I got this thing in the GitHub, in a GitHub repository. Part of the reason for that is so that you know if there may be licensing restrictions associated with it. Maybe it was licensed under a GPL license or another kind of open source license that you need to know about. But it seems like actually a pretty reasonable model for attribution where you have strings of text that exactly match underlying works. Um, Sorry, I know I'm talking a little fast here, but trying to get to
I
all these great
think we
questions.
probably